Screen share and we'll make our announcements. Okay. All right, happy Tuesday, everyone. We're going to jump right in. Going to make our announcements and then we're going to do contract training today. So I hope everyone is having a wonderful day so far. Welcome. They currently are at 85 agents in the state of Mississippi for Epic. And then happy birthday this month. We have birthdays for Cheryl Reese, Tammy Edwards, Rebecca Campbell. Happy birthday to y'all. Our July top producers, we had 42 units closed total, 13 million in properties sold. And then to date, we've had 287 properties sold to date. Our number one producer was Lee Garland for last month. Number two is Melissa Johnson. 3 is Robin Burgart. 4, Sammy Williamson. 5, Holly O'Brien. 6 is Lisa Dillon. 7 is Kimberly Hatton. 8, Wendy Colzer. 9, Hillary Copeland, and 10 is Heather Seymour. Congratulations to our top producers and all of your success. And of course, support, if you guys need support or anything like that, you know how to reach me. This is our support board. If you have any questions or anything like that, this is the guidance through that. And then we're going to go right into contract training today because we have a lot that we're going to cover. Josh is going to talk to us about CSU after. And I know we've had a lot of questions on CSU. So, but I just want to go over general, like when you're working with a buyer today, and then we'll talk about listings next week. So being that the new forms are rolling out, what we're doing is we're going to start each week with how to work with buyers. The next week's going to be how to work with sellers and so forth. So we're going to jump right in and it is recording. Yeah, it's recording. Can you guys hear me okay on the other side? Everybody hear me okay? I think they're on mute.
You're good.
Yes, ma'am.
Okay,
You're
perfect.
good, Natalie. We can
Do
hear
y'all
you
have
fine.
any questions before we get started? All right. So all of you know that whenever you start your transaction, you're going to have your working with the real estate broker form. When you're working with a buyer, you're going to check that you are working with a buyer here. If you have a disclosed dual agency, that box will be checked as well. I'm going over all this today because what I want to point out to y'all is I'm noticing a lot of boxes are not being checked. We've had some compliance issues lately and even some issues with agents where maybe you put in a percentage or a field in the inbox, but that box is not checked. And so that creates some complications when it comes to contracts. So I want to make sure that everybody is on the same page and that you are educated on what you need to do when it comes to all these new contracts. All right, so if you're representing the buyer, you're going to check buyer here. Dual agency, of course, this box would be checked here. Your licensee signature goes here. The client's signatures goes here. The license brokerage Epic, the name Epic always has to be here. Make sure you have your dates here. If you are representing, if you don't have representation and it's a customer, maybe it's a buyer that you're just working with as a customer at the time, they're not a client yet. This is not going to be checked here. You're going to check the box as a customer, and then the customer signs here. The agent will still sign here. Brokerage name still goes here. All right, buyer's agency agreement. Let's talk about that. Where's my buyer's agency agreement? Sorry, guys, give us a second. I thought we had it in here.
That's a Josh fault. I got to redo the template or add it to the template. So we'll go in and add the new one.
These should automatically populate whenever you guys are going in here to write your buyer's agency agreements. But you want to make sure that you have that F8A exclusive buyer agency contract. One thing I want to point out to you guys, whenever you are working with the buyer agency agreements, make sure that you're using the most up-to-date for errors and omissions insurance purposes as well. So you'll want to make sure that you're watching these dates down here. All right. Your exclusive buyer agency agreement is going to look like this. It's general information here, your buyer's name. I want you guys to make sure that you have all of this filled out. I've been seeing a lot of forms come across that are just kind of complacent when you're filling them out. You're not filling them out in full detail. When you're using these, we want to make sure that you have all of the information in there. So you're going to start on line 1, put your buyer's name here, put their mailing address here, phone number, email, etc. Come to 6, you're going to put the brokerage name, the mailing address of your office that you're working out of. You're going to make sure the number's here, email's here. This is a disclosure that the buyer warrants that the buyer is not subject to a current valid exclusive agreement. That means that they're not working with another agent and that the covering of the services to be rendered by the buyer's brokerage, everything is as it states it is in this agreement, that they are warranting they're not in an agreement with another brokerage. All right, so on 13, this is one of the things that did change on the buyer's agency agreement. You want to make sure that you're watching your verbiage. Here it says that the buyer hereby employs the buyer brokerage as their exclusive. Sorry, y'all, we're letting more people in. All right, let's get this. Welcome to all of you who are coming in. We are on the buyer's agency agreement, and I'm going down the lines explaining all this. So, here we've covered information. You want to watch this here on line 13. It's the buyer's brokerage as their exclusive broker agent from the time of the last signature by the buyers until this is your end date here. So your beginning date is going to be when the last person signed. Your end date, this is the ending of your agreement. This is going to be the expiration date. So you want to make sure that you're watching that. All right. It says if at the time of expiration, the buyers have entered into a purchase and sales agreement or lease option of property, which was located during the term of this agreement, the parties agree that the agreement will automatically extend through the closing date of the transaction. That means that this buyer's agency agreement has come to an end and you are currently under contract on a property. This buyer's agency agreement is going to be extended to the term of your contract and when you're closing. You also have a protection period in here as well, and we're going to talk about that here in a second. Lisa, I see you have a question.
Hey, I just put it in the chat.
All right, line 13 of the buyer's
Yeah.
agency agreement. You had a client ask if you left Epic or something happened to you, would be only held to Epic. He wants to only work with me. So this is a buyer's agency agreement between you and Epic. If you left Epic or something happened to you, so you're stating like if you got sick or something, or you just like up and left, is that what you're asking?
Right, and I'm not going anywhere,
Or
but
if
he
you
was
moved
like,
brokerages. Got you,
right,
got you.
he said, I only want to work with you.
So this buyer's agreement is exclusively between you, your client, and the brokerage. Yeah, so you would need, like, if you were to go somewhere else or something like that, you would need another buyer's agency agreement exclusively with that company. This agreement is only
Gotcha.
good for Epic and you and your client.
Yeah.
Okay, but he's not like bound to it forever if you see what I'm saying? Like if something happened to me, he wouldn't only be bound to Epic for the 6 months.
So if something happened to you, so the agreement,
Right.
all listings belong to the broker. You have a buyer's agency agreement.
Right.
I'm going to say, I mean, from broker knowledge, I'm going to say it's between the brokerage. He's bound to the brokerage at that point. Yeah, but we're not, I mean, I don't hold people
Yeah.
to, so to speak. It all depends on the client situation. I structure mine a little bit differently than most people. Yeah, everybody has a certain way that they want to structure them. And that's what I'm walking through today to talk to y'all about. So, your buyers, so let me back up to 19. This here, we've gone back and forth. We've had conversations with people too. I am choosing to leave this blank if I am working with a buyer because it's going to cover the entire state of Mississippi. So I don't feel that I need to check this box. If you have a buyer client that directs you specifically to put the geographical area, legal description, or address in that box, I would recommend you doing that if they're asking you to, simply because it's a fiduciary duty at that point. But me as a buyer's agent, I'm going to leave it blank unless I'm instructed by my client otherwise. because it tells you, like, if this section is selected, the agreement only applies to the identified address, legal description, geographical area during the stated term in any protection period. So I've chose to leave that portion blank. Here, you want to put a preferred price range. One thing that they've taught in all the classes for the new way class is to leave nothing open-ended. There has to be a beginning and an ending. So no open-endedness in your contracts and your forms that you're writing. And you need to have a beginning period and an ending period. We're just going to call this 200,000 for today. So maybe my buyers instructed me that they want to look at properties and their preferred price range. There's 200,000 to 300,000. I would put 200,000 here to 300,000. It says the total buyer's brokerage compensation, buyer agrees to pay the compensation to the buyer's brokerage as follows. You're going to choose all that may apply. I want you guys to watch your verbiage on these new forms. Some of them are choose any that apply. Some of them are choose all that apply. And some are you going to tell you to choose one option only. So make sure that you're watching these. For a purchase or exchange, this here, when I'm doing my buyer's agency agreements, I usually have 3% here. And then I'm not working with a flat professional service fee. For those of you who are, this box would be checked and a value would be entered on this blank. Non-refundable, I haven't spoken to too many of you that are taking these non-refundable fees up front, but those of you would check that box and put the value here. For me as a buyer's agent, I'm going to be checking box 30. And then this is going to cover a for sale by owner period. So additional fee of blank percentage. These two boxes are the same. So line 35 and 37, it's basically for the same thing, but you have a value of a percentage and then you have an additional fee here. So line 35, I'm going to put a percentage here. For me, that's usually 2%. So I have a 3% of the contract purchase sales price on line 35. I do 2% here. And then on line 37, I have an additional fee, and that fee is usually around $2,500 if this portion comes into play of the contract. So for a lease or rental, this is not something that you're going to worry about on the buyer's agency agreement unless you're dealing with a lease or rental. So this would not be applicable to just a purchase contract. Now, if you have to amend it, of course, this verbiage is on here. If you guys, and I'm going to use this scenario. Let's say that you were out working with a buyer and for some reason that buyer is going to have to maybe do a lease or some type of rental for a few months before they're able to purchase. You would then go and amend your buyer's agency agreement with the amendment to the buyer's agency contract, and you can amend it for this particular situation, whether you were trying to do a lease or purchase. So that's something that might happen. And then options, we don't really do those. So I'm not going to be going over this today on an option, but if you find yourself having to structure a buyer's agency agreement with an option, come to me and I will help you with that. I want you guys to look at this here. We're dropping down to line 66, and it's covering through 74. It talks about the protection period. So this has changed a little bit from the prior buyer's broker agreement. Compensation above is a total compensation to the buyer's brokerage, and this transaction is payable to the buyer's broker when the buyers enter into an agreement to purchase, lease, exchange, or option of any property prior to the termination date within so many days. So my safe space here is usually 120, not 1,100, not 1,120, 120 days after termination. That is what I usually put there. All right, buyer's broker acknowledgement, that section is here. And then you want to make sure box 99 is checked and 103 is checked. Buyers that authorize your buyer brokerage to accept any offer of compensation offered by a listing brokerage for services to the buyers up to the amount of the total buyer's brokerage compensation set forth in this agreement, excluding any compensation payable to a listing agent by a seller under a separate listing agreement. It may be confirmed by a separate agreement between the buyer's brokerage and the listing brokerage. So another thing I want to tell you guys is whenever you are, a lot of talks around that F51 form. I know when you're going to show property and you're requesting that F51 from the agent, it tells you if the seller is paying compensation or the brokerage is offering compensation. On that form, it is not a guarantee. Whenever you are writing your offers, make sure that all of that verbiage is spelled out in your purchase contracts. And so we're going to get into that in just a second. We're still going over the buyer's agency agreement for now. All right, in line 103, you want to make sure that's checked as well. The buyer instructs the buyer's brokerage to include in any offer made on the buyer's behalf, a request for the sellers to pay any portion of the total buyer brokerage compensation not paid by the listing agent. So if I'm writing this, line 99 is checked and 103 is also checked as well. You have your acknowledgements throughout here. We have breakdowns of all of this verbiage line by line as well. We will send that out to all of you agents. A few of you have requested it. We're still kind of tweaking it as some of the verbiage is being modified. Documents are still being modified by Mar as well. So just keep that in mind that those forms might change also. All right, your liability waivers and all that, that's pretty much the same on your buyer's agency agreement. You have your fair housing disclosure as well, and then attorney's fees disclosure. So, yeah, so one thing it's a really good practice for you guys. Fair housing, that is huge. There's a lot of things around fair housing, a lot of talks about that as well. Whenever you are doing a buyer's agency agreement and you have obviously you have the disclosure in here, but I also think it's a good practice to use our NAR fair housing form and have people initial that also. So it's a good practice and it shows that we are acting as we should in full disclosure. So I would include that NAR fair housing form also with my buyer's agency agreement. So working with the real estate broker, you want to make sure that that's attached here. Check this box. It's a friendly reminder to attach your working with the real estate broker. And then you'll also have your signature blocks as normal. So buyer signs here. You have your brokerage firm name here, which is going to be Epic. And then your broker's affiliated salesperson signature goes here. You'll print your name here as well. Do y'all have any questions so far? Hey, Josh.
Okay, so up here where the geographical location is.
Okay.
Somehow you like keep it open-ended. When you get something under contract and you need to do an amendment to this, do you want to push the address then or no?
No, because if you're not checking where on line 19 where it says check if applicable,
Okay,
this is automatically covering the state.
okay.
Josh's question was, should you go back and amend the buyer's agency agreement whenever you have found a property that you're going under contract with? In other words, putting that property address there. I don't think that's necessary because this form, if it's not checked, if your buyer hasn't instructed you to put that location or the geographical area on line 20, you're automatically going to be covered. So there's really no need for that. There would not be an instance in that situation that you would need to amend this buyer's agency agreement at that point. Unless somebody else on here thinks otherwise, to my knowledge, I don't think you would have to amend it.
Natalie,
Hey, Leslie.
so back up on that buyer's agency agreement where you were talking about the non-refundable.
Let me go back
professional-
real quick.
Yes. Yeah,
Right
30,
here on 32.
right. All right, so I was on a call with Charles Boyette yesterday, and
Yes.
Charles's explanation of that was that he thinks we're going to start seeing people taking non-refundable deposits, no different than if you went to hire an attorney and you have to give them a fee to, get started with them. He believes that that's what that will be used for. And, whether it's $500 or whatever, that this kind of also would prohibit people from you driving them around and showing them 8 or 10 houses, and then they leave and say they don't want to buy anything and they go somewhere else. And if they did actually go under contract, then whatever that dollar amount would be brought to the table on their behalf at closing.
Yeah, that's right. It's basically a retainer fee. You're taking it up
Yes.
front. It's non-refundable. You're saying this is my professional services fee. I like the term professional service fee. I think it sounds professional. We're not just saying this is my commission fee, this is what I charge for commissions, nothing like that. although that's what it is, you are that professional at the end of the transaction. And the term that I often refer to is my professional service fee is. So whenever you're talking to people, that's how I talk to my clients. But here, if an agent decides to exercise this option on line 32, that non-refundable professional service fee, keep in mind that you are taking a fee up front. So there's an exchange of funds, right? So those funds are going to have to go into a trust account, or it's going to have to go into Epic's corporate account. It's funds coming into Mississippi, so I'm going to say at this point it's got to be held into a trust account. It would either have to be held into a trust account here, or it's going to have to be held at the title company. And you'll notice that it says which shall be credited against the total buyer's brokerage compensation payable under this agreement. So, but yeah, to answer your question, I mean, you can, but you want to keep in mind, $500 up front, to me, it's just, I'm not doing a non-refundable professional service fee. Also, errors and omissions come into play. If that were ever to come into play, you have to think about, it says that it should be something that is a substantial amount. So $500, and then you have your fees and all that taken out of it with the company. I think that if I'm taking a non-refundable professional service fee up front, that is going to have to be something of, that's worth everyone's time too, depending on the work of what I'm doing for that client.
And Natalie, I don't disagree with you. I just, you and Bob and all of us have gone through these things to just ad nauseum. But that is what Charles was explaining yesterday, is that it would be used for that. And yes, it would have to go in an Epic account or trust account. But I just wanted to throw that out there since I had that discussion with him yesterday. It's certainly not something that I'm pushing or in favor of, but I just did want to answer that and throw that out there since it was a discussion yesterday.
Yeah, there might be some circumstances where we are taking, non-refundable professional service fee. One of you might say, hey, I really want to do this. And then you'll have to come to me and we'll figure out if it's going to go in the trust account or if we're going to put it with the title company. But as general practice, when I'm writing these, and back to line 30, 35, 37, and then the other ones that I've checked throughout the remainder of the buyer's agency agreement. So, but yeah, I do agree with you. I think that there will come a time whenever, there's an agent presented with taking that retainer up front. And then, the protocol for that is it's either going in the trust account or it's going to be held with the title company. And then it's compensated that remainder off of whatever that buyer's agency agreement is at closing. So, all right, we're going to talk about an actual purchase contract now. Do y'all have any questions before we move to the purchase contract? Okay. Anyone? Yeah. All right, so make sure this is the new one. Yep. You can watch your dates here. Its revision date was 7/2024. All right, so on your contract for the sale and purchase of real estate, the buyer's name is going to go here, seller's name is going to go here. None of this has changed on the purchase contract. So one thing I just want to reiterate to all of you is make sure that you are filling out your blanks correctly. You're not leaving blanks. You're actually putting in the information into your sales contract. Also, if you're working out of dot loop, which you should only be working out of dot loop, all of the updated forms are here. You'll want to make sure that whenever you have filled in your blanks that you are saving that information prior to sending it to your client. Again, we're getting a lot of contracts back that blanks are not filled in, or either a lot of missing information. So we just want to make sure that you guys have everything in here so that you're protected and your clients are protected as well. All right, property address, PPIN number, most of that can be found on Delta or on the tax maps, TCS maps, and then land lot as well. kitchen refrigerator, it may or may not remain. If it is remaining, you would check on line 18. Your purchase price is going to go here. This is the sales price of the property on line 19. Earnest money. Yes, we are getting deposit link. I know we've talked about it for quite some time, and we hope that is in the very near future with the help of corporate. For now, all of you are still using the attached earnest money escrow agreement addendum on your purchase contracts. That's going to be checked on line 38. So none of this you're going to check for now, only line 38, and you'll attach that earnest money escrow agreement to your purchase contract. All of this just talks about earnest money here and how to handle it. We're going to move on down to contingencies. All right, so all of you know that if you have a contingency, you would check that here, whatever is applicable to the sales contract. If it's something that's not here and you need to get creative, of course, you would check other and put that verbiage here. If it's a new loan, you're going to want to make sure that you do have new loan checked. Line 75, if you have appraisal that is applicable, that's going to go here. Maybe you have a buyer that says they don't want one, they're paying cash. A lot of cash buyers don't get appraisals. Again, it's your buyer's choice. It's always your buyer's choice. We recently had an agent, and that agent told a buyer that they did not need to get an appraisal because they were paying cash. I want to friendly remind everyone that it is still 100% the client's choice. It does not matter, you know, if you think as an agent that the client doesn't need an appraisal because they're paying cash. So I actually had to have a phone conversation with that buyer. So again, friendly reminder, it's 100% up to your client whether they want that appraisal or not. Line 75, if it's something that is financed, usually an appraisal is required, so that would be applicable. Line 80, this is talking about home inspections. So it really starts on 79, warranty and inspections. But line 80 is checked if you're not getting a home inspection. That's not a warranty. They don't have a due diligence period unless it's otherwise spelled out for a certain type of inspection and special provisions. So line 80, don't check that. If they're getting a home inspection, you want to check line 85. Line 85 for inspections. Scroll down. You have so many days to submit your repair request, and keep in mind that once you get your home, if you're getting a home, if your buyer is getting a home inspection, they're going to have 10 business days from the effective date of the contract. So 10 business days, and then the buyer's inspector, they have the right to enter the property at reasonable hours within 24 hours prior notice. So buyer's agents and listing agents, keep that in mind here whenever you are scheduling your home inspections. Just make sure that your clients have at least a 24-hour notice. All right, submit your list of repairs. There's however many days you're negotiating to have that list of repairs for your home inspection contingency. That is going to go here. I normally put 5 business days as a rule of thumb. Some of you put 3. I do 5 on the safe side. So I put 5 business days on line 100. And again, all things have to be listed in writing. Writing is your keyword in any contract. And sometimes agents go back and forth between each other. We talked about this yesterday in the class that Dee spoke. You know, we get caught up in the verbiage of, oh, you know, well, will your seller do this if my buyer requests this? Make sure that you've always got everything in writing. Writing is the key. Right. Final walkthrough inspection. So this used to be 3 days. It says, irrespective of the election made above, buyer retains the right to perform a final walkthrough inspection of the property prior to closing to verify the terms of the contract have been fulfilled and to confirm that any seller's removal of personal property is complete and has not damaged the property. So what they took out here was that 3-day walkthrough period. So your buyers have up until the time of closing to do their walkthrough now. Also, want to keep in mind for buyer's agents, make sure that whenever you have your inspection period that you are obtaining all receipts of repair work that has been done by a licensed contractor. You want to request those receipts from the seller's agent. If you are the seller's agent, you're in a dual agency transaction. Make sure that you're, keeping good records and you've got receipts to give to the clients prior to closing. All right, wood destroying insect report. We're going to move down to here. So most of this is going to be checked, but it depends on who's paying it. You either have the buyer or the seller is going to furnish. Most of the time I check on the contract, the sellers, after I've had a conversation with my buyer and ask them, they say, okay, well, we'll just ask the sellers to pay it. So that would be checked there. And then keep in mind, we're going to read this because the verbiage has changed in the sales contract. The WDR shall be dated within 30 calendar days of closing. So if you're on the listing side, you want to make sure that you're getting that wood destroying insect report done as soon as possible. So it needs to be dated within 30 calendar days of closing and shall be delivered to the other party not less than 10 calendar days prior to closing. So make sure that you have that wood destroying insect report given to the other party within 10 days prior or before 10 days prior to closing. Your 10 day is your minimum. It talks about if infestation or damage is discovered, the seller shall amend the property condition disclosure statement as appropriate and of the Mississippi Code. You have 3 calendar days to get that amended. So 3 calendar days is what I tell all of our agents. 5 days by delivery deposit of mail, but rule of thumb is you're going to be 3 days because everything we do is pretty much electronic. So. All right, we're moving down. Your closing deadline goes here. Conveyance. A lot of you leave this blank. I don't think it's a good practice to do this. Most of your contracts are general warranty unless you have like a foreclosed property or something, or if it's anything besides a normal arm's length transaction. But quick general warranty, and here on this line, it says vesting title to the property and write names clearly. This is the names of your buyers or the name of the entity that's purchasing the property. So you'd want to put your buyer's name on line 149.
Hey, Natalie.
Haley, good morning.
Good morning. Can I say something about line
Absolutely.
147, title and conveyance?
Yes,
Are you saying most people leave general warranty, special warranty, assignment of lease, or quick claim blank?
we are seeing a lot of that. Yes.
Okay,
Yes.
that is extremely dangerous. Because if
Yeah.
it's blank, because a special general warranty deed is the purest form of ownership of a property.
Right.
Most foreclosures have special warranty deeds.
That's
And
right.
quick claim deeds are even worse. So if you're leaving that blank, you're leaving your buyer subject to taking a deed on a property that is not necessarily marketable in the future, which will haunt you for a very long time. I would not leave that blank. And as far as line 149, TBD, if you don't know how they want it titled, TBD is fine, but I definitely would not leave general warranty deed blank if you know that's what the property is.
I agree with you 100%. And thank you for that, Lee. That's a lot of why we are going over these contracts today is because Josh and I, we are constantly in files checking as they come through. And there's a lot of contracts and forms that are coming across that simply are not filled out properly. They're not fully filled out. And if I'm looking at it, let's just say if something happened and we had to go before arbitration or court, I don't know how a judge is going to perceive some of those contracts. I do in the back of my mind, but I'm going to say that, they're going to look at it as the agent was lazy for not filling out these contracts properly. So I want to stress the importance of having all of your blanks properly filled in on your contracts. It's to protect you, and it's also to protect your clients as well. Thank you, Lee. All right, so prorations, this just talks about if you have any prorations prior to closing. Check if applicable, if any unused propane shall be determined as of closing. This is, you might have a cost proration here. It says check if applicable. This is your closing cost. So, your seller's contribution at closing, this is what you're asking the sellers to pay as far as closing costs. If your buyers are asking for that, you would put that amount there. Possession, excuse me. Possession is going to be taken at closing. So if you know prior to ahead of time that possibly it's either a pre or post closing possession, a lot of times pre and post closing possessions are not, that's not known up front. In very rare cases, in fact. So unless that's negotiated prior to, you're going to check upon completion and full funding, unless that this has been negotiated ahead of time. Pre is before and post is after. So maybe that the buyers are taking possession of the property a few days prior to closing. That would be a pre-closing possession. And a post-closing possession is usually to where the sellers are asking for more time, maybe to get some things out. And so the buyers are not taking possession of the property until whatever's outlined in that post-closing addendum after closing. All right, your disclosures, multiple listing service, the MLS, the parties authorized disclosures of sales data too. This is whoever you're a member of. Some of you are in multiple MLSs, you're going to put that verbiage there. Property condition disclosure statement. Buyer acknowledges receipt of a property condition disclosure statement. This box should only be checked if you have the property condition disclosure statement at the time of writing this contract in your possession. If you do not have the property condition disclosure statement, you should check on line 176 that the buyer has not received it, and they have 3 business days from the date of this acceptance to have that property condition disclosure delivered to them. So acceptance meaning the effective date of the contract when the last person has signed and that contract has become binding. All right, moving down. You have any questions so far? All right, so disclosures here, equal housing, lead-based paint, keep in mind for all of you, 1978 or prior to. I had a contract recently, lead-based paint was not marked on the sales contract, and the lead-based paint disclosure was not uploaded either, but the property was built in 1972. You have to have a lead-based paint disclosure. It is not optional. You must have it. So lead-based paint disclosure, make sure that you're watching whenever you're writing contracts. If the property is 1978 or prior, always include a lead-based paint. I even go so far as to have it, if it's 1979, I still have a lead-based paint disclosure included. So make sure that you guys are watching that. All right, wire fraud, we have wire fraud disclosures. I'm sorry, someone have a question?
Sorry, it's me again. Quick question on lead-based paint.
Hey, Lisa.
Hey. Okay, so prior to 1978, I'm just making sure I'm doing it right. Prior to 1978 is going to be 77 or before. I just want to make sure that
No,
is how I interpret it.
it was built.
Prior to 1978 would not include 1978.
Yes, 78 or before.
It's 78 or before, 1978
Yeah.
or before. That's the way I was taught in school. Lee, if you want
Okay.
to chime in, if you know
'Cause
something else different, but
I just
19
did one
I've
that was
always
built
been
in
told
19.
you have a lead-based paint disclosure 1978 or prior to.
Okay, I'll do it. No worries.
I was just saying, as an agent, even if it's 1979, I mean, I don't know if they started
Yeah.
building in 1978, that's the way my brain works. So
Gotcha. Okay.
I still use the lead-based paint disclosure.
Okay.
All right, so moving down, this is all the same. None of this has changed on audio and videography. Here as well, I want you guys to make sure that you're filling out the broker and salesperson information true and correct. The buyer brokerage firm, your name, the address of your company location. This is the brokerage firm license number here. Excuse me. Your license number should go here. Use the 888 number here, and then make sure you have your cell phone on here. Now, actually, I don't want you to use the 888 number here. And here's why. If you have somebody that needs to get a hold of me as the broker, I want them to call me and not call that 888 number. So it says the buyer brokerage firm number. You can put my cell phone there. put my cell phone number in that location, and then you're gonna put your number here. Buyer's agent email, your email is gonna go there. All this is self-explanatory. You guys just need to make sure that you're filling it out to full detail. All right, agency relationship. This has to be checked. It is not optional, not optional. We've had a few where you guys have not checked agency. That'll get you in real big trouble with the real estate commission. So whenever you're in these forms, make sure that you're filling it out. Agency is important. So make sure you guys are checking it. Compensation. All right, all of this is the new stuff that's changed. So here, whenever we're talking about compensation, the buyer brokerage compensation, the buyer shall pay the buyer brokerage compensation by separate agreement. There is no buyer brokerage compensation. That means that there's no buyer's agency commission here, or the buyers have entered into a binding agreement with the buyer's broker, agreed to the total buyer, excuse me, guys, agreed to the total buyer brokerage compensation as follows. If I'm the agent writing this, I'm checking box 245. Here I've got the percentage here of the gross sales price. This is your total commission here. And then if you are asking the seller to pay some commission, that percentage is going to go here. And so I'm going to put this here. My buyer's agency agreement is 3%. I'm going to ask the sellers to pay that here whenever I'm writing the sales contract. Here you have the percentage paid by the buyers and paid by the listing broker. And if you have the, one thing we need to point out, if you have the commission being paid by the listing broker, you're going to want to have to request that F38 form. All right, buyer warrants that the total buyer brokerage compensation set forth above does not exceed the authorized buyer's agreement with the buyer's brokerage. In the event the transaction fails to close for any reason other than the seller's default, sellers and/or the listing broker shall be released from any obligation to make any payment to the buyer's brokerage. All right, moving down. By signing this contract, the buyer and seller acknowledge receipt of this disclosure and agree to hold the brokerages and their agents harmless from all claims for damages arising out of or relating to any representations in this section. You have your disclosures here. They read and understood it. This is about an assignment of a contract. Most of you are not working with any assignments, but it says here, this contract shall not be assignable by either party without the consent of the other party. Effective date, survival of the contract, time is of the essence. We all know that. So here, seller's email should go here, listing agent's email here, buyer's information here. This should be filled out here. Special provisions, if you're asking for anything in the sales contract, your buyer's instructed you to put, maybe it's the earnest money. So one thing I want to note, when you guys are using the earnest money escrow agreements for now, you have 24 hours by contract law to get that earnest money into a trust account. If your buyer is mailing an earnest money check from out of state, you would want to come into the special provisions and you would want to put a verbiage here that buyer is to mail earnest money within so many business days to whichever title company it's going to be held with, and that verbiage is going to go in special provisions. So just a friendly reminder for there.
You don't have none, right?
Yeah, and if you don't have anything that you're putting in the special provisions, again, we're going back to that. There's a beginning and an ending. We don't want to leave anything open-ended. So you would simply write none in the special provisions. And it tells us that there. It says if there's no verbiage, if none, write none. So you'd want to put none in the special provisions. Expiration of the offer. Make sure you're watching your timelines too, when you're in negotiations and all that. So offer expires at whatever that would be. Your date's going to go here. I know we've talked about adding things to a contract, but one thing that I do want to stress to you guys, I've preached this for quite some time, but I just want to reiterate it again. So if you have something that has, maybe it's a post-closing possession or a pre-closing possession, maybe it's dual agency, whatever those forms are that you have attached to your sales contract, you want to make sure that you're checking these boxes. So just make sure those boxes are checked there. Also, if you have lead-based paint, 1978 or prior to, you're going to make sure you have this lead-based paint disclosure checked here. If it's something that you're attaching to the sales contract, so like the fair housing poster, for instance, I might put that there's a fair housing disclosure. And then you have your earnest money escrow agreement addendum. That's automatically checked by contract on the second page, I believe. But if you want to go that extra step, you could also put that here. You could put your earnest money. So whatever additional forms that you're attaching with your sales contract, you would want to spell that out here. I think that's a really good practice to do.
If you don't.
Hey,
have
Danica.
The lead paste disclosure yet,
Mhm.
like you're requesting it, like, hey, I noticed this, so would you check it or wait until you have it and then do you need to amend it at that point? Cause oftentimes I'll need to, when I'm writing an offer on that the seller
Yeah.
doesn't have it uploaded.
Danica asked a really good question, and this is how I would do this in my practice. So if I don't currently have the lead-based paint disclosure from the listing agent, I do not check this because technically it's not part of the sales contract yet. But what I do is in the special provisions, I put that the lead-based paint disclosure is to be delivered to the buyer's agent within so many days. And then I also back that up with that it's not in my possession yet. So it's just an extra safety measure that I use when I'm writing my offers. If I don't have that lead-based paint disclosure just yet, if it hasn't been given to me, I don't check that box. But if I do have one of those forms in my possession that are going to go with the sales contract, then I put that in.
Okay, so the same thing with like the FHA addendum, you know, if it's gonna be an FHA loan, you know that's coming.
You know it's coming,
You
yes.
know it's coming, but don't check it until you have it.
That's right.
Okay.
Yeah.
Okay.
Yeah, she asked another good question. So like your FHA addendums, so if you don't have it yet, but you know that it's coming, I don't generally, as a rule of thumb, check any of these forms to the sales contract if I don't have them in my possession. So only if I have them, then I check it on the sales contract. And of course, all your signatures are here. These are all the same. Nothing's changed here. Buyer signs here. If the seller's accepting, they sign here. If they've countered, the seller's going to sign here. Or if they've received a recopy or rejected it, that'll go here. Also, if you have a backup contract, maybe another offer's been accepted on a property, but your buyer really wants this house and they'll say, hey, you know, we're willing to make this deal work. Here's the terms. We would like to be a backup contract. If it's accepted, the sellers will sign here. So this form can also be used as a backup contract as well. All right, y'all have any questions so far?
I had a question about the attachment. Whenever, what about personal property agreement? You know how the lenders are like, don't send me that, like FHA, stuff like that. So I just had one where like everything in the house stays. And I know how the lender is going to be like, nope. And then I had one with land and I put that attached because it's a little bit different. What would you do? Like, what would you suggest?
This is my general practice. If I know that I have a personal property agreement ahead of time, I still put it on the sales contract. And here's why. The contract agreement is between the buyer, seller, and the agency. I put it on there. Now, if the lender comes back and they tell me that they don't want to see it, to have it removed, I do an amendment to the contract by addendum.
Okay.
But I still have disclosing that I've already prepared that document because that document's going with the purchase contract when I'm sending it to the listing agent or if I'm the agent, vice versa. But so the way I work my business is if I have those forms in my possession at the time of writing the contract, I notate everything on the sales contract, unless a lender tells me otherwise. I have put the verbiage of a personal property agreement in here. Now, they generally don't want to see it, but I can't really think of any times that I've had them to say, hey, remove that personal property agreement. So the only time they want it removed usually is if you spelled out like personal property, saying in special provisions, or if that has a value amount, then that's probably going to warrant for do an addendum to remove it. But if there's just like the personal property agreements attached, I do check other, and then I spell that verbiage out there.
And the majority of the ones that we do, we typically assign no value to the property. It's just included.
Yeah.
So if it's not a part of this contract and it falls through, at that point, is your buyer, can they go to court and demand they give those personal belongings for free? I mean, if it's not part of the contract and the contract falls through, are they still, is the seller still held, responsible to provide those items for no cost? So if it's not attached to the contract and you have an agreement where they don't give it to you for free, then it's just something to think about.
So the personal property agreement is a separate agreement from the contract. The personal property agreement basically is a contract by itself. And it states that it is only in effect if the contract is executed and finalized.
Yeah.
Gotcha.
So, your personal property agreement may say for a fee of $10, you get the riding lawnmower. But it is subject to the contract finalizing for it to take effect.
Yeah.
Okay.
Thank you, Lee. All right, we're gonna move on to amending the contract. So where's the amendment at? What's the amendment?
Go to if applicable. That's the buyer's agency agreement. So let's go find.
I need those.
F45.
There we go. All right, here we go. All right, checking to make sure it's the updated one. All forms, again, they're updated in .loop, but I just double check. So, all right, so if you're having to amend your purchase contract, of course, you're gonna name the amendment name here, whether that's A, B, or C, 1, 2, or 3. And then the agreement contract for the sell and purchase, you're gonna have your effective date here. All the property description is going to be here. And so if you have to amend it, of course, there are sections here that are going to be applicable. You have your buyer's amend to read, seller's property address, if that changes. This is any changes that are pertaining to the purchase contract. This is usually used after everything has been agreed upon. You would amend your purchase contract if there are changes to it. So maybe the earnest money amounts changed. If that's something that were to change, that would have to be agreed upon. And of course, that's spelled out here. So that's just one example. Also, you might have a situation where maybe closings got extended for a little bit longer and the seller says, hey, I'm willing to extend, but I want your earnest money and it's going to be non-refundable. In that instance, you would come here and you would check line 16. Earnest money is made non-refundable to be credited against the purchase price at closing. If the closing does not occur, the earnest money to be retained by the seller. With credits against any amounts due or become due from sellers to buyers attributable to the contract. So that is where that would come into play in that scenario there. If the loan contingencies are changing, I recently had one on a personal listing. Agent on the other side's been doing this for a while, but I had the appraiser called me and the purchase contract was written as conventional. The appraiser calls me to tell me he's going out to do the appraisal. Contract terms had changed 2 weeks prior to, and nobody said anything. We did not get a contingency change or anything like that. So here we were, we had multiple offers on the property. We had 3 really good offers that came into my seller. He chose the one that he thought was going to have, the least headache with the property. He was, you know, thinking, hey, it's conventional, it's a really good offer. It was like full price offer. Well, the loan got switched to FHA. 2 weeks went by and nobody said anything. The appraisal was done FHA as well, and we thought it was being done as conventional. So a lot of you on here are well aware that if you have an FHA appraisal, that's usually on record for 6 months. So that would have been a, you know, deciding factor with my seller at the time on deciding if he wanted to accept FHA loan contingency. It is a contingency of the contract. And so my point is, if that contingency changes during the contract term, and you know you've got to disclose, so you would want to make sure that line 19 is checked and whichever type of contingency change here. Maybe it's not spelled out. Maybe it's something else. Maybe it's an in-house loan and there's just all these crazy factors behind it. I'm just throwing something out there. That would be other, and then you would spell out that verbiage there. But back to, if anything changes within the contract, you'll want to make sure as far as the loan part that you've got that spelled out there. Bridge is other, yes, bridge loan. The question was, would a bridge loan be considered other? And that would be considered as other. That is usually done in-house with a bank. So cash deals, you know, be Section 5 loan contingency waive. This is where cash comes into play usually. They're just waiving everything. They're going to go to close and then they're paying cash. So that goes there. Section 5 inspections is amended to extend the inspection period from 10 to whatever business days. You can add business days there, or you can subtract, you could take away. So maybe, I don't know, maybe you've got a multiple offer situation and you want to get in there and get your inspections done quick and you don't want to hold the contract up. That might be something that you would want to use there. So Section 5 inspections is deleted. Maybe you have your inspection period is deleted. You would do that there. If you're amending to change the number in the blank on line 100 to whatever business days, that comes into play here. Deadline to close. Also keep in mind, if you've written a contract and maybe you're closing within 30 days, if the lender comes back and says, hey, we need 5 more days to close, and your contract's only good for 30 days and you need 35 days to close, you're going to have to come in here and amend your contract. So you would want to put that verbiage there. Seller contribution at closing. This is whatever the seller's paying in closing costs. That goes on line 27 if that changes. Compensation, also maybe compensation's changing. Maybe there's some factors coming into play with whatever it is in the contract. Maybe there's some loan contingencies that are having to be fulfilled. Compensation's having to be reduced, or maybe compensation, let's say that compensation is being increased. Just throwing that out there. Then you would come here and you would amend your contract for the sell and purchase here with the compensation here. All right, make sure all of this information is here. This here is the seller agrees to remove any of the following items and repair any damage caused by their removal prior to the date that is at least 7 calendar days prior to the date of the final walkthrough inspection. That verbiage would be spelled out here. Title company, closing of the sale shall be conducted by title company changes. That's also a change to the contract. Maybe you had something spelled out in your contract and special provisions that the closing was to be held at Luckett Land Title. And all of a sudden the bank says, hey, we got to change title company. You know, maybe they're not on their approved list, whatever. You would come here and you would put the name of the title company here. If you're doing an amendment to the contract is amended to reflect the following repairs to be made at seller's expense by qualified parties prior to the date of the final walkthrough inspection. That's exactly what it says. It's made at the seller's expense prior to the walkthrough, and with receipts to be provided by the buyers prior to the final walkthrough where available. Also, if you have additional repairs listed that need to be attached to this, maybe you don't have enough verbiage, you can check this box and add an addendum to this agreement. Buyer waives for receipt of a property condition disclosure statement and consents to proceed to closing. That would be checked there if that comes into play. Maybe the buyer just says, hey, you know, we're gonna remove all the contingencies and we're going to closing. Then you would check line 78 here. Buyer elects not to exercise the first right of refusal and acknowledges that the contract is null and void with the buyer to receive a refund of their earnest money. So if the first right of refusal is not coming into play, that's going to be checked here and that earnest money would be returned to the buyer. Maybe you're having to terminate the contract. Maybe financing fell through. Maybe the appraisal wasn't good. People could not come to terms. You still have to terminate a contract. So you would come here on line 87 and it says the contract is terminated. The earnest money, deciding who gets that, either the seller or the buyer. Of course, these are conversations that have been had prior to creating this document, but this would be checked here. So whichever party is receiving the earnest money. And that's your amendment to your purchase contract. Do y'all have any questions? Like I've done a lot of talking. Do I have any questions at all?
I'll ask one question.
Hey, Danica.
So after you've like gone back and forth with repairs,
Mhm.
if you negotiate verbally at all, does it extend the repair negotiation window? Like if you allow them to keep having inspections for their, so could you deny them?
Everything has to be in writing. So Danica's question is, the agents go back and forth verbally. They're having conversations verbally and about repairs. The contracts say that everything has to be in writing and spelled out clearly and agreed upon by all parties. It's be a mutual agreement. It's a binding agreement in writing. So contract law tells us that it has to be in writing, unless there's something I'm missing. I believe that it's got to be in writing 100%. I mean, I don't think verbal would ever hold up at that point. I think you're going to have it spelled out in writing, and both parties agreed.
At what point do we need to have sellers amend the PCDS? No matter what, after the home inspection and you've negotiated repairs, should we always be amending the PCDS at that point?
If it's something that they know, if there's a material change to the property that wasn't disclosed prior to, it should be updated immediately, as soon as possible, and delivered to the other party.
Like the other party's aware of it because they got
Because of the home inspection. Yeah.
right? So should we just always amend the PCDS? Because they're gonna bring things to our attention that we weren't aware of, right?
Yes, because the law says if you know, you have to disclose. And so
Okay.
now that home inspection has been done, the seller is obligated to go back and update that PCDS.
Okay.
And if they're fixing things, the question was, like, once the home inspection is done during the, like with property disclosure, my take is, it says that you have to update it. You have knowledge, the seller knows, the realtor doesn't update it. Let me be clear on that. The agent doesn't touch it. Yeah, you can.
Both two ways.
Okay.
With other realtors, and I've kind of done it both myself. Had a complete amended PCDS at closing for the buyer to sign that they did based off the home inspection. Or there's also a provision in the home inspection contingency addendum now, the new one that we use, that says
pull that up real
all
quick.
previous, this ratifies or this modifies all previous disclosures. There is a line on that, and that was brought to my attention by another realtor one time. So that's kind of what I've been saying and doing. If anything's said about the PCDS, there's a line on there somewhere that says this shall change any PCDS, legal verbiage.
The property condition disclosure statement.
On the home inspection contingency addendum. It's
So
on the home
pull
inspection.
up everything needs to be in writing. And you need to, so on the amendment, let me pull up the property condition disclosure statement and show you guys where you would amend it on here. Let me on your inspection contingency. Yep. Okay. All right, so your inspection contingency notification amendment, this is where you're asking for the repairs to be done. Says hereby removes the inspection contingency with the following repairs being completed at the seller's expense by qualified parties prior to the date of the final walkthrough. It's always done prior to the walkthrough. Again, you see that verbiage with receipts being provided to the buyer prior to the final walkthrough. You also can continue that on additional pages as well. So it tells you that any other, yeah. It says that any other amendments to the contract should be addressed using Form F45, amendment to the contract for sale and purchase of real estate. And then except as otherwise stated, use of this form does not excuse the seller from any obligation to amend that property condition disclosure statement. So that is your answer. The seller knows the seller has to disclose. Josh wants me to go back to this inspection contingency for a minute.
So when we're countering this, a lot of people just do counter and then maybe a blank addendum, or even, we've just seen the counter, nothing after that. It clearly states down there, use F45 for the counter. So we want to see this counter signed by the seller, and then the seller sign F45 and list the amendments or whatever the counter is. Or
Can we look at the F45 and the verbiage on that?
We're going to pull up F45 while we're talking about this. Do y'all have any questions so far about what we're talking about as far as disclosures and disclosing things of the property once it's found out?
We're not even before closing, because that's what gives them the 3 days. So if you wait till closing, it's too late by that point. So we need to do it like right here, when we're sending this over, we need to send the, you know what I mean? The change back.
I agree.
All right, so here in section, starting on line 60, says the contract is amended to reflect the following repairs to be made at the seller's expense by qualified parties prior to the date of the final walkthrough inspection, with receipts to be provided to the buyers prior to the final walkthrough where available. It tells you, we went over this, but it says continue on additional sheets if necessary. The seller's and the buyer's agreement concerning repairs amends any previous disclosures. Yes, as to the repaired items. And you would check here if it says see additional repairs listed on attached lists incorporated herein by reference. So
does 74 amend our previous PCDS?
So 74, yeah, I think it does, because they're disclosing, and it tells you the seller and the buyer's agreement concerning repair amends any previous disclosures as to repaired items. Lee, do you have a take on this verbiage here?
Just an opinion on what Robert Prater would say. And
Okay.
you've heard him say this many times. These forms that you guys fill out, what your association does and what your MLS does is not my circus. So he doesn't care what these forms say. What he cares about is what does that state statute say about the PCDS? And the Real Estate Commission has provided a space on the PCDS for amendments. I wouldn't want to fight that battle.
No, I agree with you on that. So let's pull it up real quick and in the wrong placeholder. Here we go.
You've heard him say, not my monkey, not my circus.
Not my circus. That's exactly what he would say. All right. All right, let's look at the PCDS. So we're going to go to the amendment section. All right. Here, I wanted to go over this real quick while we're on the PCDS. This is an additional explanation page. This is not to amend it. So this section here, the additional explanation page, it says the PCDS often presents boxes in which to provide explanatory details on various topics, including an instruction to attach additional pages if necessary. So where this form comes into play is if the sellers maybe needed to explain something that they've done to their property upon listing this property. They are putting extra verbiage upon the additional explanation page. This page is not to be used to amend the property disclosure. We're going to scroll down here. This is the section that you would use to amend the property condition disclosure statement. This is the only amendment that you would use. So this is part of the property condition disclosure statement. Your seller is the only one that is going to touch this form. You as the agent are not allowed to fill this form out. You're not allowed to touch it. You don't sign it. There's no place for you to sign on there. Only the seller and the buyer. So the amendment to the property condition disclosure statement, which we formally refer to as a PCDS, you may use this model form to amend an existing PCDS by completing this amendment form and attaching it to the front of the existing PCDS. So what that tells you is whenever your seller client has amended the property disclosure, this form needs to go on top of that property condition disclosure statement. It should be the first form that the buyer is seeing whenever this PCDS has been amended. It says using the same process, multiple consecutive amendments may be made over time. So maybe they amended the property disclosure, but then they've had all the repairs done and the air conditioner breaks. They got to disclose it. They're going to come back, say, you know, when it broke, when they had it fixed, if it was remedied, maybe it didn't have a remedy, but they would still use this same form to come back and put that verbiage in here and add that as an amendment.
A real life scenario would be you get through inspection period
Mhm.
and you amend it after that. And then the appraisal comes back subject to. So you have to make those repairs as well. And then you would amend it again. So you use two different amendments.
That's right. Yeah, Josh just gave a really good example. He was stating that a real life scenario would be you've gotten through the repair process and the seller has amended that property condition disclosure statement. But then here comes Mr. or Mrs. Appraiser and they have subject to on that property. There's things that maybe it's a material defect to the property or it's something that needs to be disclosed by law of the PCDS. That verbiage is going to be put on this amendment to the property condition disclosure statement, and it's going to be added on top of that amendment that you already have.
Natalie,
Hey, okay.
on this amendment, what all are we listing? Is it everything that pops up on that inspection? Even
Anything,
things that we didn't agree to fix?
Material defect.
anything that
Okay,
is
any material de- well,
a
I-
material defect to the property.
Material defect, so. And that's how they got out of the contract. I'm just saying, that's what happened.
A loose doorknob. Do y'all think that that would be a loose doorknob? Is that a material defect to get out of the property?
GFCI, smoke detector,
Yeah.
safety related,
Part of the property,
Anything on that inspection,
electrical.
Handrails,
handrails, yeah.
steps, like stairs.
Yeah.
There, like all kinds of stuff.
So basically, we just need to go through and list out everything and have the.
A good rule of thumb is if you know, disclose it. And then if, you know, you've got a copy of the relevant portion of the home inspection report. And I would go so far as to attach that relevant portion to the disclosure as well. That's my 2 cents on that. Seller's name, and then you're gonna have your date. It's previously signed and dated by the sellers on, you're revising it. So you just put your revisions here. The seller has a placeholder for the seller to sign, date it, and then the buyer has a place to sign acknowledging. So y'all have any questions? We've covered a pretty good bit. We've covered buyer's agency agreement. We've covered a sales contract, amending your sales contract. And then we've also talked about property condition disclosure statements as well.
Heather asked a question on how can you send it to your seller in dot loop for your buyer to fill out in a fillable form? I don't know the answer to that. I know I send it from MREC's site personally, because I send it in a separate email totally. Because from MREC's site, it's a fillable PDF that can be saved halfway through it without a signature and can be edited if it's wrong. So I send it that way. When it comes back to me, I review it. And then I send it back to them through dot loop for their final signature. I've found that has been a much easier process in dot loop unless there's something I don't know, which could very well
But I
be.
was thinking of like when you have to amend it, when you have to add, you know what I mean? You already downloaded it, already filled it out, you gotta send it to them to amend. I was trying to figure out how to do it in dot loop.
There's two ways you can do it. The way Lee is doing it was the way I always did or would send the property condition disclosure statement to my seller prior to dot loop. But you certainly can do it both ways. And I went ahead and pulled this up on the Real Estate Commission's website. So obviously this is all fillable. And when you send this to your seller, they can come in here and fill it out accordingly. So that is a good way to send that property condition disclosure statement to the seller and let them fill this out. So another way on dot loop, there is a way to fill it. I'm going to let Josh talk to you guys about that. I know the steps. So if you come in here and you share it.
Yeah.
Let me just type a name real quick. Heather, you should pop up here. All right. So on here, where it says you have an option, you're going to select can fill and sign. You're going to click on that. And then I might say, hi, Heather, please. Oh, sorry, Heather, I've misspelled your name. Hold on. Please have PCDS fully completed. Let me know. And then I followed up, let me know if you have any questions. I put my cell phone number in there too, just so they have it. I'm always the person that wants to make sure everything is covered in here. So like when I send this to them, I tell them hi, tell them what's in there for them to complete it, tell them what they should do with some instructions. And then I say, hey, if you have any questions, let me know. And I put my cell phone number in there. I don't attach it as a PDF because it's not fillable at that point. So don't click this. So you don't make note that you don't want to click to attach PDF. Whenever you want to send it to the other party to fill and sign, you're just going to select can fill and sign. Make sure that you have that checked, and then you're just going to share it just like that. Yeah. And then you also have to require the role. So I'm just going to call you the buying agent on the other side. Although you would be the seller filling it out, you would say seller here. So seller, and then can fill and sign, and then share it. And that's it. Once it goes to your seller's then able to fill out that property condition disclosure statement directly in dot loop.
And it's a good practice to send that separately because the rest of the documents we're sending.
And Josh made a good point. I do that as a good practice. So if I have a listing agreement that I'm sending through dot loop with all of my listing forms, I send the property condition disclosure statement separate so that they're able to focus on that after they've done the listing agreement. Yeah. So any questions? All right. We've gone for about an hour and 25 minutes today, so we're going to wrap it up. If y'all have any questions, you guys let me know. You've got my cell phone number and Josh's number as well. So, and then there's 2 videos that you guys need to watch. I believe notifications have been sent out on that. One is going to be CSU, and I'm sorry, they're both CSU. So both are how to navigate through CSU whenever you're creating those CDAs through there. All right. Well, I hope you all have a wonderful rest of your week. And if I can help y'all in any way, please let me know.